Well, hello, Internet New Media Law class, and welcome to the lecture for Class 2. And in this class, we're going to talk about some of the basics of web media law. And really what we're going to talk about is some basic issues involving copyright, which is, as we mentioned last week, one of the most important aspects of intellectual property that applies to what we're calling new media. And we will talk about the Digital Millennium Copyright Act and the safe harbors under the Digital Millennium Copyright Act. So the first thing that we want to do in talking about this is to remember a little bit about how the web works and what an internet service provider, or as the DMCA calls it, an online service provider, does, and why there are issues about potential copyright liability for those providers. We'll talk about primary and secondary copyright liability, and then we'll talk about the specific safe harbors under the DMCA OCILA and a few cases that I gave you to look at for this week. So the first thing that I want to do is remind us a little bit about how the web works. Now, you might recall us talking a bit about this during our internet law class. So you have individual computers, like the computer that you might be using to watch this lecture on, and we'll call those peers. And then we've got some kind of way for those computers to connect to the internet. We'll call that a server, and here we'll call it an ISP, an internet service provider. So your computer, through a modem, is going to be connecting to your ISP. Your ISP then is going to have servers that are taking those connections, and is going to have routers that are then routing out that traffic. If you remember from our first internet law class, we talked about how packet switching works, and remember that your traffic is going to be broken up into individual packets. And those packets are going to find their way through various routes around the net, and these nodes will be nodes that have routers, and then eventually your packets are going to be assembled, and they're going to get to wherever they're going. Let's here call it YouTube. Now YouTube is going to have its own servers, its own storage space. Of course, the way I'm drawing this diagram, it's much more complicated. YouTube is going to have servers all around, out in the cloud, so to speak, in a variety of places, and then there are going to be internet service providers that are providing service for YouTube. There are going to be routers and switches and so on that all of this is going through. But just what I want you to notice from this diagram is that you, the individual peer, transmitting some content over the internet, your content is going across equipment that is owned and operated by entities or persons other than you. And so what happens if you, in fact, are transmitting infringing content, content that infringes someone's copyright over the internet? Is this entity, this internet service provider, liable for the content that passes through its routers? Now recall when we talked a bit about how computer technology works in the internet law class, that there's going to be some kinds of memory in the servers on this on the internet service provider's network that is going to briefly store the information that you're sending in a cache, so that it's able to kind of read it and kind of route the package and decide where they have to go. It's just the way routers and computer technology work, that there has to be some storage, some temporary storage, very brief, in cache memory. But that storage creates a copy. And there is case law in copyright law suggesting that caching, making a copy for caching purposes, can be a reproduction, which can violate the reproduction right. Then, of course, the content is going perhaps somewhere like YouTube, where it's going to be stored more permanently, or at least for kind of a longer period of time, on servers controlled by YouTube, so that somebody else, if this guy wants to watch your silly cat video, he can call it up from YouTube. So you've got it going across the devices and routers and so on, and potentially being in cache memory of a service provider, and you've got it in storage for a different kind of service provider that might be a Web 2.0 entity. These kinds of storage raise issues for us in terms of copyright liability. All right, so let's talk a little bit then about primary and secondary liability for copyright infringement. So primary liability for copyright infringement, if we use our example again of you transmitting infringing material that you have created over the internet, you are directly violating one of the exclusive rights of copyright, which are found in Section 106 of the Copyright Act. So you're making a reproduction, you're making a distribution. So you would be directly violating those rights. Secondary copyright liability is liability for someone other than the direct infringer who is facilitating or making possible that infringement. And when we look at some of our cases in a moment, we'll see some of the details of what we mean specifically by secondary liability. But just for our purpose now, keep in mind that someone like that internet service provider, someone like that YouTube who is making it possible for you to engage in the direct infringement under certain doctrines of copyright secondary liability could also be liable for copyright infringement. And of course, from the perspective of the owner of the content, especially if it's something like, a movie or a music file or some other content from a large media provider, it's going to be much more desirable for them to be able to go after that internet service provider or that YouTube-like provider because they're easier to identify, because they might have assets that are easier to get at, because they may even be cooperative and want to resolve the case, and because there might be large quantities of infringement going through some of those channels or pipes. So it's, from the perspective of the media owner, much better for them if they can go after that intermediary. Obviously, from the perspective of the internet and having an open, functioning internet that allows for user-generated content, it's pretty difficult to say that the intermediary should always be responsible in those circumstances, because what you'd really be saying as a matter of internet governance is that those intermediaries are responsible for policing copyright infringement. And if you get into those kind of circumstances, you may actually create legal barriers and economic barriers for the web to even work. So the international community recognized this in the WIPO, World Intellectual Property Organization, Copyright Treaty in 1996, and the United States Congress recognized it in bringing into a general provision of that WIPO Copyright Treaty regarding facilitating the internet and electronic commerce into the details of OCILA. We will also see that there are elements of the DMCA that involve copyright protection measures, technological protection measures such as encryption. Those are also part of the WIPO Copyright Treaty. Those are a key part of the WIPO Copyright Treaty. Those are also part of the DMCA, but that's not what we're looking at here. Here we're looking at these safe harbors. So I have here listed the 4 potential kinds of safe harbors, and we'll take a little bit more detailed look at those in just a moment. But notice that each of them, transitory communication, system caching, information that's residing on a system at the user's direction, those I think are pretty clearly part of the process or dynamic that I was just showing you a moment ago when we were reminding ourselves about how the internet works. This 4th one, internet location tools, sounds a bit odd, but really what it's about is things like hyperlinks, like ways of finding files on a site. Are you linking to another server, another site that might have infringing content? Now we'll look at some of the details of these safe harbors in just a moment. Notice that for all of the safe harbors, and each of these safe harbors has their own kind of requirements and limitations. Notice for that for all of these safe harbors, there's a threshold. And the threshold is, number one, that the online service provider has adopted a policy for termination of repeat infringers and is implementing that policy reasonably and is informing subscribers of that policy. And as we'll see in just a little while, there's plenty of litigation over when does the service provider have knowledge of repeat infringers, what kind of policy do they actually have to adopt. And then secondly, the service provider accommodates and does not interfere with standard technological measures. And this just means kind of standard measures that are taken by the copyright owner to identify and protect their copyrighted material. Okay, let's look in a little bit of detail in some of these safe harbors. And this is in 17 U.S.C. 512. So here is the first part on transitory digital network communications. And notice this deals with transmitting, routing, providing connections through a system or network. This is just what we were talking about in terms of how the internet works. So here are the requirements. The transmission is initiated by a person other than the service provider. So again, the subscriber sending the stuff over. The transmission is carried out through an automated process without selection of the material by the service provider. So in the ordinary course, you're sending an infringing MP3 file through a peer-to-peer connection to somebody else, and it's routing through your internet service provider. The provider isn't selecting that file. The provider just has ordinary protocols that all traffic uses. So that's what that provision is about. The provider does not select the recipient except as an automated response. So in other words, the provider isn't identifying who the recipient is. You, the sender, are determining who the recipient is. The provider is not making a copy of the material except for some kind of intermediate or transient period necessary for the transmission to work. So the provider itself is not storing in any kind of long-term storage the material. And the material is transmitted without being modified. The provider is not adding anything or taking anything away from the content. So in essence, Part A is just saying the internet service provider is simply acting as an internet service provider, routing traffic, and it's allowing the provider to sort of be traffic neutral. Okay, system caching. So here we say the provider is not liable for material that is in intermediate or temporary storage. And again, this relates to the transitory digital network communications, kind of like a belt and suspenders. The material is made available by a person other than the service provider. The material is transmitted by a person other than the service provider. The storage is carried out through an automatic technical process, right? So once again, the service provider is just acting like a service provider, and the law is allowing them neutrally to do that. Notice also that there are a number of conditions for the system caching safe harbor under Section 2. And if you read through these, you'll see that they all relate to the fact that the service provider is acting simply as a service provider, is not selecting the content, is not selecting the user, is not using any kind of special technology, but is simply acting as a service provider. Section C is one of the big sections that there's been a fair amount of litigation on, and this is information that's residing on a system or network at the direction of the user. So notice that the first two sections are transitory. It's really things going through the network, and in many ways is kind of dealing with that first level of internet service provider. Now, materials at the direction of user is really dealing with what we today call Web 2.0, which is users generating content, users manipulating and using content that resides on the server, the storage of some service, like a YouTube, for example. So notice the requirements in Section C. The provider does not have actual knowledge that the material is infringing. And as we will see, this section is a section that has been and is being hotly litigated. So it does not have actual knowledge. In absence of actual knowledge, basically doesn't have constructive knowledge, is not aware of facts or circumstances from which infringing activity is apparent. And upon obtaining knowledge of infringement, the provider acts expeditiously to remove it. Also, the provider does not receive a financial benefit directly attributable to the infringing activity if the provider has the right and ability to control that activity. Again, as you might imagine, a hot issue that's subject to litigation. And third, upon notification, the provider acts expeditiously to remove the infringing material. And this is the notice and takedown procedure that we talk about in the context of the DMCA. The provider must have a designated agent who is available to receive the notification. This doesn't need to be sort of anything fancy. It just needs to be someone, an actual person who's able to receive the notice electronically. And then there are requirements in Section 3 for what the notice needs to contain, the notice that there is infringing material. And so you see the list of those elements here when you read the statute in that notice. So the fourth safe harbor is these information location tools. So notice information tools including directory, index, reference, pointer, or hypertext link. And again, there's actual knowledge, there's constructive knowledge, and there is a duty to remove. And again, there is the requirement that there's no direct benefit where the provider has the right and ability to control. And again, there's a notice and takedown. So both as to stored content and linked content, very similar kinds of features. All right, so let's look at some of the cases that I asked you to read for this week. And we'll talk a little bit more about some of these when we meet together in class, but I wanted to go over some features of these cases and to kind of point out some of the things I want you to notice in these cases. So the first one is Ellison v. Robertson, a Ninth Circuit case from 2004. You will see in copyright law generally and in internet and new media law in particular, the Ninth Circuit and the Second Circuit, very important circuits. It doesn't mean other circuits are not important, but these are very important circuits where there are Silicon Valley companies, where there are Hollywood media companies, where there are New York media companies. So there's a lot of action, and they're very important. The Seventh Circuit also sometimes comes up with interesting and important decisions in copyright, particularly from kind of a law and economics perspective. Other circuits as well. But you see Ninth and Second, you know there's something potentially interesting going on. So this case is about Ralph Ellison, a science fiction writer. This is him here with his wife, and a picture from his, Harlan Ellison, picture of him with his wife from his website. So one of the interesting things about this case is it really shows the early context in which the issues of the DMCA first arose. And so if you read this history, if you are old enough like I am, you will remember specifically the Usenet and the news groups, which really were very much like kind of a threaded email discussion on an email news list, for example, today, like on Gmail, you might have the ability to thread the discussion. News groups were somewhat like that. So you'd have a topic like, just came into my head, telescopes. I have a hobby of using telescopes. So you would have a Usenet group. It would be about telescopes. Someone would post, has anyone tried XYZ kind of eyepiece when looking at Saturn? And a bunch of people might comment. So you have a discussion that kind of goes on a topic, like a threaded discussion. That was a Usenet group. So Usenet was a very big deal, and in one of these early Usenet groups, there's a user who is making digital copies of some of Ellison's work and distributing it in the form of sort of an early type of ebook. So, it's interesting to see that early context and really what the DMCA was first enacted to deal with. It gives some history of the DMCA and OCILA. And I think one thing to note here that's interesting in this case is that in the DMCA and OCILA, Congress chose not to rewrite copyright law for the Internet. There were debates about whether copyright law should be really substantially rewritten for the Internet era, but that's not what Congress chose to do. What Congress chose to do was try and just give the kind of exemptions and safe harbors that we have seen in order to make some adjustments without completely rewriting the law. Ellison also very nicely lays out the kinds of indirect copyright infringement that exist. So on the one hand, there is contributory infringement. So notice the standard for contributory infringement. With knowledge of the infringing activity induces, causes, or materially contributes to the infringing conduct. And notice that this also includes actual and constructive knowledge of the infringing activity. And then vicarious infringement, the defendant enjoys a direct financial benefit from another's infringing activity and has the right and ability to supervise the infringing activity. So you can see that, and Ellison mentioned some case law, earlier case law, as well as the Napster case, and we'll look at some of that case law in a little more detail when we talk about music copyright. But you could see why under these standards, without safe harbors, there's a good chance that courts might find an internet service provider or a Web 2.0 company liable for infringing activity of their subscribers. Notice also another interesting kind of early internet history piece of this case, which is that the service provider involved is AOL, America Online. So America Online was a huge player in the early internet space. It is not a huge player anymore. But at the time, a lot of the early internet cases, online cases, deal with America Online. So here, America Online really didn't have a proper agent set up who was really able to receive takedown notices. And because the agent didn't timely see the notice from Ellison's attorney, the majority in the Ninth Circuit held that the threshold for the safe harbor, there was at least an issue of fact as to whether the threshold for the safe harbor was satisfied, and on summary judgment, denied summary judgment. Okay, the next case that I asked you to look at is the Lenz versus Universal case. This also is a case from the Ninth Circuit, a very recent case, 2016. And I want to show you the actual video that was at issue in the Lenz case. And as you read the case, you'll see that the takedown notice was served by the holder of the copyright in Prince's song "Let's Go Crazy." So here is the actual video.
What do you think of the music?
And that is it. So the issue in this case is when sending a takedown notice, does the copyright holder have to take into account whether the use might be fair use? Now, we will look a bit more at fair use, again, when we talk about music copyright and the Napster and Grokster cases. Fair use under the copyright is in the 1976 Copyright Act. There are 4 factors to determine whether a use is fair use or not. You have to look at the nature of the copyrighted work. You have to look at the amount and substantiality used. You have to look at the nature of the allegedly infringing use, and you have to look at the effect on the market. So it's something that takes a bit of analysis in many cases, and certainly, or at least possibly, a clip like the one we just watched with some background music and a little baby dancing, there are at least arguments that could be fair use. For one thing, the effect on the market is likely to be very, very small, or if anything, maybe it might drive you to actually say, oh, I remember that song. Maybe I'll download pay for a copy of that song on iTunes or something like that. Given that only a short clip is used, given that the effect on the market is small, given that the nature of the use arguably is transformative, it's showing this little baby dancing, a fair claim that it's a fair use. The debate here, and we'll talk more about this debate when we meet together in class this week, is that copyright owners are able to send these takedown notices without really having to prove that they own the copyright, without having to prove that there's infringement, and at least prior to the Lens case, without having to prove that the use is not fair use. Now, if you were to bring an infringement claim in court as the copyright holder, of course, you would bear the burden of proof, A, that you own the copyright and that the right is valid, and then B, that there is infringement. So the notice and takedown procedure, although it does facilitate the ability of the internet to function without these intermediaries having to worry too much about whether they're going to be liable for their users' infringement, it does allow copyright owners to really police what happens online to a far greater extent than litigation would. And of course, it's a lot cheaper, and of course, it's also a lot faster. It's basically immediate. Now, it's true that the user has the opportunity, if they want to contest the takedown notice, but most users don't. If you really care about it, maybe you'll just try to post it again somewhere else using different keywords or something like that, or you'll just let it go. Occasionally, someone will contest it. Ms. Lenz, in this case, did contest it. Actually, turns out she's a bit of a copyright kind of activist. They sort of picked on the wrong person. She did contest it and contested it even in court, but it's relatively rare. So that's part of the debate, and that's part of the thing we'll talk about. Now, one of the arguments that Universal made was to say that, well, fair use is an exception to the normal law of copyright, and fair use is an affirmative defense that ultimately the defendant would have to prove, so that the burden should not be on the copyright owner to first look at content they want to take down and decide whether it's fair use. And the Ninth Circuit said, no, that's not how it works. The Ninth Circuit said fair use is not just excused by the law, it is wholly authorized by law. This is a very strong statement that fair use is not just some kind of minor exception to copyright, but fair use is part of the very fabric of American copyright law. Further, the Ninth Circuit says fair use is not just an affirmative defense. Even if procedurally it is pled as an affirmative defense, the fact remains that the copyright holder's rights only extend to things that are not fair use. And even if it technically has to look like an affirmative defense, the Ninth Circuit says we're not going to treat it like an affirmative defense for the purpose of the DMCA. And so the court says a copyright holder must consider in good faith prior to sending a takedown whether the allegedly infringing material constitutes a fair use. Now, there's a very interesting concurrence in this case because the majority, kind of the procedural posture, the majority ends up sending the case back and saying, Well, there's an issue of fact here about whether Universal really, in good faith, considered whether this was fair use. The concurring judge says, I don't even think that's a triable issue of fact. It can't have been good faith because they didn't really consider the question of fair use at all before they notified YouTube to take this video down. So what's the deal with that concurrence? The concurring judge felt like under the majority's rule, a copyright holder can do a kind of cursory look at fair use, say they've done good faith, send the takedown notice, and then if there ever is a fight, which again, rarely will someone contest this, but if there ever is a fight, that big media company has deep pockets, they can fight it out through trial against some individual. Whereas Judge Smith said he doesn't want it to be that way. He wants it to be a more bright line rule that if fair use is really not thoroughly considered, then someone who's contesting this is entitled really to relief very quickly. So that's an interesting little twist in the case. So notice this is the rule in the Ninth Circuit. It's not yet a universal rule. It's not yet a rule that the Supreme Court has looked at. Generally speaking, I think big media companies that are operating in multiple jurisdictions with this important precedent, they're going to be taking this into account. So the last case I want to talk about that I asked you to look at was the YouTube case, which is a Second Circuit case from 2012. Now, this is a really important and interesting case, obviously because it involves one of the big guns in Web 2.0, which is YouTube, which of course is owned now by Google. So this case, because of the players involved and the platform involved, was and is a big deal. So, some of the factual background, if you've ever used YouTube, you'll be familiar with some of this background. You can read it in the case, right? But the user uploads a video. In fact, the video that you're watching for this class, I make the video and I go through exactly this process and upload it to YouTube so that you can watch it. Surveys at the time showed that a large number of YouTube streams contain copyrighted material that's owned by other people, and therefore potentially that there's a lot of infringing stuff on YouTube. Also, you'll see in the case some of the factual background prior to Google's acquisition of YouTube. There were some hot documents from some of the founders of YouTube who were really just kids, kind of showing that they knew that the platform would be used for some infringing purposes. So the court goes through the analysis and looks at the safe harbor provisions, and here are a few of the issues that come up. So here's a summary from the court of the different elements of the safe harbor provision. Now, I said that a lot of YouTube content has material owned by other people. Yeah, and some of it might be like this. So this video I'm showing you, I showed you the Prince Let's Go Crazy video. I'm going to show you this little clip because really the big issue in the YouTube case is what they call red flag knowledge. So the question of should they have known, just based on the volume of material which goes through their network and the volume of material which goes through their network and on their servers, which is copyrighted by others, should they have known that indeed there was infringing content? This is a scene that relates to that issue from one of my favorite movies of all time, Casablanca.
You see what I mean? If Laszlo's presence in a cafe can inspire this unfortunate demonstration, what more will his presence in Casablanca bring on? I advise that this place be shut up at once.
But everybody's having such a good time.
Yes, much too good a time. The place is to be closed.
But I've no excuse to close it.
Find one.
Santé, monsieur.
Everybody's to leave here immediately. This cafe is closed until further notice. Clear the room at once.
How can you close me up? On what ground?
I'm shocked to find that gambling is going on in here.
You're winning, sir.
Oh, thank you very much. Everybody out at once.
So I'm shocked to learn that there's infringement going on here. But of course, those percentages could be misleading because I certainly believe that the clip that I just showed you was a fair use of that clip. Now, I don't know if the original person who uploaded it, if it's a fair use by them, but I'm definitely convinced that what I'm doing, a small portion, not hurting the market, educational context, I have no doubt that it's fair use. Okay, so on this question of actual knowledge, a few things from the case. So there's an interesting question about actual knowledge in the statute that the Second Circuit points out here, because if there is a removal obligation, then you must know that there's some infringing material on your site. And so what kind of knowledge do you have to have? So here the court says there's an issue of material fact regarding with specific instances of the material that the particular plaintiffs in this case were bringing up, whether YouTube knew about those. And that was really an issue about kind of the record in the case. The court then talks about how to understand this red flag or constructive knowledge kind of issue in the safe harbor. And the court focuses on the question of willful blindness and suggests that there's a common law doctrine of willful blindness, and that is tantamount to knowledge. That is the same thing as knowledge. And the DMCA, the court says, puts somewhat of a limit on the willful blindness doctrine, although it doesn't abrogate the whole doctrine. So, why is this, right? I mean, willful blindness might be saying, I'm not even going to look. I'm not going to monitor. I'm not going to look. I don't want to know what is on my servers, what is on my network or not. And if you're doing that, and there's a lot of infringing or unlawful stuff going on, then you may be responsible for constructive knowledge under this common law doctrine of willful blindness. But if that's the case, the Second Circuit says, then the whole purpose of the DMCA kind of collapses, because the whole idea is to make the provider, the internet service provider, the Web 2.0 provider, be just a neutral platform and make the user primarily responsible for infringing content. And so if the provider has to be constantly monitoring and has some kind of duty of care for a particular kind of monitoring for infringing content, the court says that would really go beyond the whole purpose of the Second Circuit. So the court kind of punts and says, well, we're really not sure exactly what is required under this doctrine given the DMCA, and we can't decide it on summary judgment. We're going to punt. We're going to let lots of facts get developed, and we'll see what happens. Then you've got this question of, well, what does it mean under the safe harbors for the service provider to have a right and ability to control? Well, one thing you could say, and this is something Google argued, right and ability to control means I know of a specific file that's infringing and I have the capacity to remove it. But the court says it can't mean that, because that would make other parts of the DMCA redundant. Because once you do have specific knowledge, you certainly have an obligation to remove it. And this is really supposed to be a threshold for the safe harbor applying. So it can't mean just that. On the other hand, it can't be coextensive with vicarious liability. Because if it's coextensive with vicarious liability, then there's really no reason for the DMCA at all. It's really not doing what it's supposed to be doing, because remember, the DMCA is adopted to provide safe harbors in light of contributory liability and vicarious liability. So it must be that it's more than just a technical ability to block specific files. What that is, again, the Second Circuit kind of punts. They say, well, there's a few cases out there that talk about, specific control over the way things are laid out, specific control over kinds of content, but we're not really sure what it's supposed to mean. And again, what the media providers are trying to do is to say this law requires certain kinds of technologies for filtering content. And what Google, YouTube is trying to say is, no, that's, the law is not specifying certain kinds of technologies. It's a technology neutral, platform neutral kind of law. And the court is saying, we're not really sure what to do in this context. And again, we'll remand it for further fact finding. All right, then we've got this other piece of the case that talks about where the statute is saying that the infringement has to occur by reason of storage on the service provider's servers and at the direction of a user. And the court says here that YouTube at least does clearly fall under this provision. There's another aspect of this, which is third-party syndication of YouTube videos. And that question there is whether it's at the direction of a user. And again, here the court's going to ask for further fact-finding. So what ultimately happens to this case? How does it get resolved? I think all of the issues that get flagged show how complicated it can be to write and apply a statute to the kind of media that we're talking about, especially, we moved from the Usenet groups to something like YouTube. We've moved from really somewhat more neutral platforms like an AOL with news groups to a platform like YouTube with very sophisticated abilities through Google to use algorithms and other things to try and at least initially screen some content. How do we want this statute to work out? How should the law work out? Court kind of punts. The case is remanded. What happens? The district court finds no liability on the facts. And then there is a settlement. And the settlement, I think, is really interesting. So here is a quote from one of the press releases around the settlement. Reflects the growing collaborative dialogue between our two companies, Google and Viacom. This is part of that question of convergence. And this is a way in which the backdrop of the law, there's litigation going on. The litigation is certainly designed, to get a certain kind of result. It's also designed, I think, to highlight flaws or issues with the statute that potentially Congress might address. It's also designed so that the players can sort of, set up a battleground or a playing field to fight things out until they can reach some kind of agreement. And this is a real interesting dynamic where you've got now huge Web 2.0 players like Google and huge media companies agreeing together. How do we feel about that? What do we think about that? You probably have seen in the news this past week the news of the AT&T Time Warner merger. Another aspect of the concentration of these industries, whether it's through settlement agreements, mergers, other sorts of things. These same issues, right, playing themselves out over and over again. So, it might seem they kind of reached this deal, but interestingly, Viacom did get technologically, at least, as part of this settlement, some of what it wanted. So Google did adopt a filtering technology called Content ID that detects copyrighted works and then sends notices proactively from YouTube to the media companies saying, hey, this file from your work, this looks like it might be a file from one of your works. Do you want to do a takedown notice? And a large number of media companies are using it. Now, notice this, I think is really interesting. They may use it to take the content down. They may use it to sell ads against their content. So a really interesting way in which this collaboration is affecting what is really supposed to be this user-generated space, and is, but nevertheless has this significant overlay of big media companies watching it. Now, this was interesting too. This was as of 2012. So as of 2012, Viacom was saying, we really don't view YouTube as a channel for most of our content. We think that there are other kinds of apps, other kinds of pay TV operators that are better outlets for us. Viacom has a number of cable network channels that they're already doing this in a way through cable. But a lot of them at the time were thinking of, having their own portals, so that if you wanted this content, you would log in and have a username, perhaps have a subscription to the portal controlled by the media company, rather than distributing their content through a channel, a portal controlled by Google or somebody else. Why? Of course, because that relates to how you control the content, how you monetize the content, what else is shown with it. This now is 4 years old. I think Amazon Video, Netflix, and even now, as we see, some of the content deals that YouTube is working on are already starting to change this dynamic. But I think this is a really interesting illustration of how the backdrop of the law and litigation affects. The litigation is really not just for its own sake. The litigation is in the context of a much broader business strategy that's going to result in it'll result in case law, but it'll also result in potential congressional action, and it'll also result in potential business deals. Okay, so that's the end of the video lecture portion of this class. When we meet in class on Thursday, we'll do some things together that play off these questions of safe harbors, of the policy issues that they raise, and how it relates to what we might see as the future of new media on the web. I'll see you in class on Thursday.